His ex-wife, when I say a monster, she's a monster. His ex-wife is bonkers about money.
Well, it's not fair.
It's not fair. Said to her, send me money, send me money, send me money.
This is what happened. It's not fair.
How can I send you money when I don't have a job?
See, that is just not fair.
Welcome back. Today we will be covering the latest Sarah Boone letter that was just uploaded yesterday on August 4th, 2026. I know you thought you heard the last of Sarah Catherine Boone Paulsen.
Excuse me. You're eating my peach. Cupcake. I don't want a peach. Cupcake.
That's a lie. No one ever thinks that she's going to ever stop, and she just proves us right time and time again. In this next debacle, this is a letter written to the DCA, try to write directly to her appellate courts. She's trying to go up to the tippy top to get everyone in trouble because he's not doing what she wants him to do. Are we noticing a pattern here with Sarah and her lawyers? How every single one of them fails her, refuses to work for her, ignores her, so on and so forth. I'm trying to see how quick I can get this video out, so I'll try to keep things streamlined. But first, if you're new here, welcome to the world of long-form rant content where there is no structure or goal. It is just me reacting to whatever I want to react to, however I want to react to it. And the video is finished when it is finished. I assert no authority or expertise on this channel. You take what you take, you leave what you leave. But if you leave a like on the way out. That's just good home training. Without further ado, let's dive right in. But pause, I'm going to swap the order of how I'm going to approach this because Sarah sent a letter and then she sent her appellate attorney's email as proof of her claims, allegedly, at the end of the letter. I'm going to swap that and do his letter first so we can directly compare it when we get to her letter and how she categorizes what her lawyer said. So we'll start with his letter, then get to hers. To Sarah Boone on May 21st, 2026. Mrs. Boone, you mean Miss Boone. I have received your letter dated May 13th, 2026, wherein you state that you did not receive a copy of the brief I filed on your behalf. I am not sure why you did not receive that copy, as I definitely mailed a copy to you as soon as I filed it, so I am enclosing another copy herein in hopes that you actually receive this one. With respect to the phone call, and as I made aware during our last call, I ordinarily do not call inmate appeal clients on court-appointed cases as I prefer written communication. I simply do not have the time or resources on this case to schedule yet another call to discuss the brief, as the brief is self-explanatory, and I made the best arguments I could on this case in light of all the circumstances. As far as what to expect next on the appeal, the state will have an opportunity to file an answer, and the matter will then go before the appellate court for review based on the brief submitted. I will not be filing any reply brief and also will not be scheduling any oral argument, as I do not believe it is necessary in this matter. And oral arguments are generally not granted on these matters anyway from the appellate courts. With respect to your wish for me to keep Nicole informed as to what transpires with your case, enclosed herein is an attorney-client privilege waiver for your completion. Please review the waiver, sign it, and mail it back to me at your earliest convenience. Once I receive it, I will be happy to provide her with the brief as well, and I can correspond with her to keep her apprised of any case updates. Sincerely, David Maldonado. And that was Mr. Maldonado, Esquire's email to Sarah Catherine Boone Paulsen.
The killer is eating my peach. Cupcake. I want a cupcake. Help me!
And I don't know if her other attorneys ever sent her emails. I know this is the first email we've seen from another attorney. But if this was the first one, congrats, Sarah. You finally got a response from one of your lawyers, and they're telling you the exact same thing they always do. It's the same repetition of no one's giving me answers, no one's telling me anything, and then every person who tells her these things says, she doesn't like my answer, you're not accepting my answer, the answer doesn't change. She did that with Miss Cashman.
And I do not trust her. So I have prepared this for you. It's a letter and then a continuation of the letter from the video visit, so you are aware of. And everyone constantly blames me that I am the reason why I am supposedly on attorney number 8, which I am not the reason for any of them. I put this in here also so you are aware. Again, I refuse to be mistreated by her as my attorney. I'm shocked that she has a proposed trial date, considering the fact that I have not seen anything. I keep asking her for just a download of my phone, of my medical records, or for anything that I've asked pretty much all of the other attorneys as well.
She has asked me repeatedly for a copy of some medical records. Based on the discovery I got from the previous attorneys, one of the copies of those medical records had her handwritten notes. So she had a copy given to her previously. She'd reviewed them with previous attorneys. I sent her a new copy. Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to, and you try to explain that to a client.
All of my questions that I keep asking her are in a letter to you. I didn't know if you would be the one to help me answer them or to spur her to finally answer them to me and hopefully truthfully. I don't know.
A few minutes later.
I just simply wanted to have her do a motion for a bond hearing.
But the statement that you said is that Ms. Cashman, who's an officer of the court, has lied to you. And what you've provided me so far is not evidence of any lies based on the severity of the charge.
I believe, because she's not fully explained it to me other than what she's asked me for that I tried to provide to her, was that I just need to give her an address. And that's what I gave to her, and then it turns into everything else. And then it turns into all these other different stories of why she won't do or why she has said certain things. It always changes and it mutates. And then it turns into all these other different stories of why she won't do or why she has said certain things. It always changes and it mutates.
So she does answer your questions. You don't like the answers. It always changes and it always mutates, meaning she is always responding to you. She did that with Judge Kranig.
My question is, was a notice of hearing posted or mailed to anyone to where apparently the news crews obviously got it? How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court? Just very odd to me that the news knew about it before I did.
Again, I can't speak to that.
How is it the news knows before I do?
You keep asking the same question and the answer is going to be the same. You keep asking the same question and the answer is going to be the same. I cannot answer that question for you because I do not know.
I really don't know what to say, and because I supposedly have no way to contact you other than a letter, and the same for you, I don't know how the news crews got here before I did.
I've already explained.
Ask the news crews how they got here?
No, ma'am, I'm not going to let you do that.
She claims no one answers her because she doesn't hear what she wants to hear. And that's why he says, in regards to the phone call, just like our last call when I told you, I don't work for broke people.
Hide the money, y'all. There's poor people around. With your broke ass.
Okay? I'm court appointed, meaning you are getting my free labor. If you want my paid labor, you need to have paid money. Which obviously, yes, he is getting paid for this case from Florida, but he's not getting paid to go above and beyond and to have excessive amount of communication that normal people actually pay extra for. That is an absolutely reasonable boundary. And that can make you feel how you feel, but that's what it means when you have a free lawyer. Some of these lawyers make anywhere from $100, $200 to $400, $500 an hour for their time. And most charge by the minute. So if you want a 15-minute phone call, that's $100. You want a half hour, which you always demand, $200. You don't have money for that.
Insufficient funds. You ain't got no money. With your broke ass. Woo.
Each minute, what, is around $6, $7? No. And you're asking for them to put a pause on all of their things in order to do more for you. And the only reason she feels comfortable doing that is because of the popularity of her case, which is why she keeps releasing these publicly uploaded letters. They're rarely, if ever, actually written to the judge. I don't think she has ever once gotten anything that she wants from a letter to the judge that was not a motion. And she knows this after 5-6 years, so it is an intentional choice in order for us to know about this.
I actually have an envelope, please, that I would like to give to you regarding a letter. It's a lot easier for me to tell you in writing, and it's also put on the clerk of the court's website, so everyone is aware.
And I'm guessing she's hoping, just like her criminal trial, that if she complains loud enough, someone will want to swoop in and save her like Superman. Like Lois Lane looking in the skies for Superman, I'm hoping, praying for an attorney to step up and truly represent me with honesty, intensity, understanding, respect, and perspective. And you get their time for free. And you expect premium A+ service? No. That's why he said, write me. That's what I prefer. You like writing anyway. You've written 10,000 letters, so this should be right in your wheelhouse, your ballpark. You should be the happiest ever. But he does a great job. Maybe he has seen how she reacts with lawyers in the past, so he was just covering his bases of, you sent this letter on this date. You said you didn't receive a copy of the brief when I already sent it to you, so I'm going to put written again that I'm enclosing another copy. I just don't believe her when she says she doesn't get these things, because how many times has she said she's wanted multiple copies of everything and that the copies she gets are never good enough, and then she complains on these phone calls about having too much paperwork and having no space, and all of her property is just the paperwork she begged for.
And so every day I don't sleep, every night I don't sleep, because I'm terrified they're going to wake me up in the middle of the night, tell me, I have to pack all of my stuff, I have to drag it all the way over there, I have to stand there handcuffed holding all of my stuff, and you don't understand, 90% of my belongings, because I don't have anything else, are my court documents that I have from my criminal case that I might be doing something with at some point in my life when Josh Adams contacts me.
And honestly, at a certain point, I don't know how, if this is allowed or not, but she's always talking about, I don't have paper, I don't have paper. Why don't you go through the stacks of copies you have and find the pages with the least amount of text and use the back of it? I don't know. Make it work, or at least use those pages to practice your letters on so that you're not wasting whatever little paper you can get, but whatever. Those documents act both as a battle scar and a reward that she will never get rid of. Yeah, but I just love that. I do not normally call broke-ass inmates
With your broke ass.
for yet another call establishing we've already talked about this to re-explain a self-explanatory brief. He said, I made the best arguments in light of the circumstances. I might have to disagree on that one. I did read the brief. It's a hot ass mess. But so is this case. So I don't know. There's not much he could have done to make winnable arguments. He could have made these arguments better, but it wouldn't have changed anything either way. And that was one of the reasons why Miss Cashman withdrew originally. I didn't say the first half of that, but that's what I do sometimes. I'll start in the middle of conversations with people and they'll be like, oh, you didn't hear the first half that was in my head. So back up to the court appointed inmates. Because he has other paying clients, spending so much time on you for free takes away from the service other people are paying for. JJ, on June 11th, 2024, Cashman moved to withdraw under Florida rule regulating the Florida Bar 4-1.7b2, substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client. Other people are on call for Mr. Maldonado. He will drop anything he has to answer their calls because they're paying him to do so. You think it is your legal right to demand A+ perfection from your lawyers. And no, you don't. Mr. Maldonado said you do not get Michelin star service at Burger King prices. I don't care if they tell you you can have it your way or not.
Welcome to King Burger, where we could do it your way, but don't get crazy.
You won't get your way here.
I got a complicated order!
Says I made the best arguments I could in light of the circumstances. I'll put a pin in that because I do want to briefly talk about the arguments in the brief before we move on to Sarah's letter, because I still haven't covered the brief, but, you know. And he gives her a clear game plan of what's moving forward, of the state will answer this brief, I will not be replying to it, nor will I ask for oral arguments, which already aren't granted normally in situations like this. The reason there's no reply brief is because it's not necessary. It takes more time for absolutely zero payoff.
Can I get a number 6 with a cookies and cream milkshake?
You sure you just don't want a Coke? I gotta get the ice cream out, put some cookies all up in it. I don't even know how to use that blender. They got me pressing all these crazy buttons. No, you can have a Coke. Next!
Besides her feelings of it would make me feel better if you kept going as far as you possibly could. And if you don't do that, then you're not representing me. And then wraps it up with, if you want me to keep Nicole informed, here's this waiver. I guess that means her and Nicole are still friends despite her dogging on Nicole every chance she gets.
So like super effed me up with stuff that she was helping me with in this my statement. So I'm not going to be able to get it to you until tomorrow. So I just wanted to make sure you were aware, and you said it was okay, but I just wanted to give you a heads up. Thank you. Totally effed me, dude. You don't understand. I know she's trying to be helpful, but I cannot describe it to you. Like, I've had to do an entire section, and I was like, look, if I have to call you so you can explain it to him, because you're not going to be happy, because a complete section has to come out and be re-added. I had to redo a whole section.
Okay.
Okay, well, I'm taking it to heart when you say, okay, it's the attorney's fees section. I have no paper.
Can Nicole copy and paste this stuff and put it all together in one document? And then you
I've been
guys...
trying to talk to her for 2 days with no response.
She's not responding to you?
I don't know if her cat died. I don't know if something happened to her son. I don't know. She's in Australia.
Still pissed off at you?
She was never pissed off with me in the first place. She wrote me back and said it was just a misunderstanding, and she's happy to help.
She was pissed. She was definitely pissed. She sent me an email. But regardless,
like, what's wrong with you? Seriously.
And I wasn't giving you a hard time about. I'm just trying to give you some insight and tell you, like, yeah, she might say she's not pissed, but she was pissed. I mean, she was upset.
Ask me if I care. Flip the next page.
Why don't you care? Why wouldn't you care about that?
I don't have time to care about that right now. And what exactly do you propose I do about it right this moment? Yesterday or the day before, after then writing her an email confirming our
apologize to her
for everything that she does.
Yeah, but like apologize to her and tell her like.
I don't need for you to tell me what I've already done.
I don't have time to care about that right now. And what exactly do you propose I do about it right this moment?
Please.
It doesn't sound like you apologize to her, but whatever. It's not my thing.
Absolutely, just like I did Lana's, and everything else. And then it always comes back to bite us in the ass and say, I told you so.
Honestly, Sarah, I think that like people are going way out of their way to help you. And you shouldn't say, like, ask me if I care. I don't think that's right. I mean, like, you could say the same thing to her about me tomorrow.
That's your paranoia. That's your paranoia.
That's not.
I've done everything that I possibly can. And the thing is, though, at the same time, you don't have conversations with her on a daily basis. You don't work with her extracurricularly on these things to try to avoid and alleviate things for you to ask for me to ask you to do. You're not there. You're not in the relationship between me and her, and you don't understand.
Yeah, but I know the fact.
Do, and everything's fine. And she's on a regular basis. She does go like this because she's 16 hours away and has a broken phone and a dying cat. And I told you it's very difficult working with her because if I tell her the box is red, she tries to tell me 150,000 ways how the box is red, what the box is made out of, and like all of this. And it's just like, I just wanted to confirm that the box was red.
Okay. Yep, that's definitely pretty frustrating.
It's very frustrating to me because I'm on the phone with her, and it's just, and then she's like, call me back. And it's like, you guys don't understand what it is for me to talk for 30 minutes to try to get everything I possibly can, summarize it, whatever else it is, and then have to wait 30 minutes, fight other girls for the phone, and get on it again over and over and over and over again. Because the next thing you know, 3 hours has passed. and she gets an A for effort, and I totally love her, but it's very difficult considering she lives, 16,000 miles away?
Yeah. Okay. So you think that she spent her entire weekend writing like 6-page documents?
What is the point of this?
You're bringing it up.
Oh, man, I don't know. Like, do you want me to feel really bad about
No.
Because I feel really bad about and you're just mutating it.
I don't want you to feel bad. I just don't think that you should say
About this whole situation.
Can I just finish what I'm going to say, please? I don't want you to feel bad. I just don't want you to say things like, ask me if I care, because this is someone that's spent a lot of time and loves you and is trying to help you. And for you to say that is...
I'm talking about this moment right now.
Okay, but you think that doesn't hurt any more? Like, if I heard you said that about me, I would be upset.
When I say, ask me if I care, I mean, do you want me to care about it after it's already been resolved? That's what I'm not understanding.
I don't know.
Now that
Don't use my government name. You call me New York.
Now that New York is no longer there, she has no one else. So now the help that she complained about is the only person she has left. And I actually asked New York if he had any advice at all for Nicole moving forward.
Any words for Nikki? I mean...
Well, Nikki, we love her. I've spoken to her several times, Collectively, I feel like we were a little bit disappointed with her, but I feel like she needs to spend a lot of time with, because somebody got her off track and she needs guidance back home.
I know.
But he did say that he put in a waiver so that she can waive her rights, so her lawyer can talk to Nicole about everything now and get a brief. Nicole still won't be able to do anything right in Sarah's eyes, but at least it's an option now. Okay, so that was the email. Now I want to break down the main 4 arguments in the appeal brief so that you know what we're looking at when we're going into Sarah's letter of what she's complaining about. Okay, so Mr. Maldonado only pulled out 4 key arguments for this appellate brief. And honestly, I'm shocked he even got 4 issues. They're not really all issues, but this case is so airtight that he tried to squeeze any little thing he could out of them.
I'll do the best I can, but when I got...
Kinda poorly, but he at least did it. Better than what she would have done, which she was this close to doing it herself. And I want you to remember the ultimate goal of this appeal is to have the conviction overturned and given a new trial, because all of the violations were so over the top that it was an unfair trial that would have or could have altered the verdict. That is an incredibly high standard, and normally in appeals you want to come out the gate with your strongest argument and build that way. So what is our argument number 1? The trial court erred in improperly limiting the appellant's opening statements regarding the quote overt act requirement. That's literally the best. That's what he thought was the strongest argument here, was an opening statement argument. Now, when I actually cover the briefs, we'll expand into each one of them more and more, but I'll just, summarize some things now. But this dealt with those fake ass black eye photos that Sarah just wanted to show the world so bad. Look how beaten up she has been. And it all looks fake. People have said it looks like marker, it looks like shoe polish, it looks like anything but an actual black eye. And I agree. And she wanted to show these pictures in opening statements. However, Kranick said no, because 1, the overt act, to assert the battered spouse syndrome defense that they were going for, she had to testify first to an overt act. That's why she had to testify. She could not avoid the train wreck that we saw. It was the only way to bring this up. Kranick allowed him to talk about prior acts of violence and this and that, but not allowed to specifically get into battered spouse syndrome because she had not yet testified to that overt act. And if she has not testified to that, and these also aren't material to the case at all, you are not going to bring them into opening statements. I can't rob someone and say, look, here's a picture of him pushing me off a swing 2 years ago, so obviously it's okay I committed the robbery on that night. What? No. So he said, I will let you bring it up. You just can't use those pictures. This is also opening statements. Opening statements is not evidence. Those pictures were allowed to come into evidence. Moreover, they used those pictures in closing arguments. That's what I don't get. You want to say that they didn't see the pictures, so they didn't have the right perception and this and that, and so that formed their opinion. However, closing arguments and when these pictures were introduced were later on in the trial, closer to when they actually deliberated. So they saw these pictures moments to hours before going back there to deliberate. So how could it have been more impactful to see the same pictures at the very beginning of the trial that you also see at the end? If he had not let you use those in closing arguments, then there would be more of an issue there. But opening statements before any evidence has been introduced, they say you have a wide latitude with opening statements, but it doesn't just mean you can bring up anything ever. They could bring up prior acts of violence in order to establish her mental state, but when you're introducing pictures, you're trying to project the image of this is what she looked like that night. She didn't look like the shoe polish black eye. She didn't look like the slight little split forehead that literally is just a little cut. And, you know, looking at it closer, it's not just a little cut. It's definitely a gash on her eyebrow, but it doesn't match the reports and the accounts she gives. She says she's always defenseless, normally in her room, hidden somewhere. He's bursting in with abusive rage and is just wailing on her as she is defensively saying, please stop, and I did nothing to him.
Is that what you're telling me? Or what happened? I need you to tell me.
He kicked the door open. He's kicked the
You're
door.
adding a lot of details that I need you to be very concise with.
Yes, sir.
When I'm telling you, I need a timeline of the events.
Yes.
How am I going to corroborate your story?
He kicked the door open 4 times.
Uh-huh.
4th time, I gave in. Okay?
Mm-hmm.
That's when I got punched in my ear. On the 4th time. Where I was like, don't do it anymore. Just go downstairs. Go smoke a cigarette. And that's what I did.
Okay.
And then I walked off barefoot.
Okay. And on the phone, you told me that you attacked him as well.
I didn't attack him.
You said you exchanged, you had a physical altercation on the phone. That's what you told me.
I pulled him off of me.
He said he has marks because I was fighting for my life.
I was being honest with you.
Okay.
Hands behind your back.
For what?
For battery domestic?
Me?
Both of you. You two hitting each other.
Oh.
This
is for real?
This is for real.
Why am I in trouble though?
Because of
Why
the
am
marks
I in
he has all on his neck and the inconsistencies of the story.
Back. Why? Because I fucking fought back?
And that's why it's always so obvious when abusers inflate or try to absolve themselves while inflating the actual victim's responsibility, and it just doesn't match. You want us to overly see his actions as abusive while erasing your actions and his injuries, which is why you are so dumbfounded when Chelsea said, this is the same thing. You should have been arrested just as many times as he was. You are just as abusive.
He nor I.
Well, he's dead as a result of your actions.
on each other.
He is dead as a result of
I
your
understand
actions.
that.
So,
That's why this...
You two didn't lay hands on each other.
No. No. I don't have anything.
You're right.
He doesn't. Whatever that is, whatever it is.
He does.
See, this is what happens. It's not fair that you guys, just because he has those, automatically blame it on me. Like,
well, what about when you had your injuries and he gets arrested? Is that not fair?
Really? Like,
It's
really?
the exact same thing.
Really?
Is that not fair? Really? Like, really? Exact same thing. Really?
Really?
He has injuries. You have injuries. Like, what does that mean?
I don't have any injuries.
Correct.
Because
So
he and
nothing
I
happened to
have
you.
not been at it with one another.
I don't have any injuries.
Any injuries?
Correct. Because he and I have not been at it with one another.
So every time that you guys fight, you both hit each other? So you should have probably
No.
gone to jail all those times that he went to
No.
jail for domestic?
Well, the one time I did. But he completely trashed the police report.
Because that's nothing what happened. Because the reason why I got taken in was because my story was different than his.
$10 back. For what? For battery domestic? Me? Both of you. You two hitting each other. Oh.
So I'm being portrayed as like this abuser. So I'm the one that's being portrayed as the abuser. Because I have never dealt with anything like this before. I don't know what to do, how to do it, and I always know what to do and how to do it. This, I don't know. So I don't know, like, what's going on or, like...
And funny enough, I just noticed that when she interrupts them after she's saying, so I'm the one being portrayed as the abuser, awkward pause.
So I'm the one that's being portrayed as the abuser.
Chelsea starts to say, because he, and at the same time, Scott starts to say, because you are.
I have never...
So she was probably going to say something because he was the one found brutalized and murdered and dead. And he was probably going to say, because you were the one found without an injury or a scratch on you. That's why you're being portrayed as the abuser, because you are one. Either way, those two incidences had nothing to do with Happy Fun Day Sunday. It was a great time. Everyone was having fun.
Everything was fine and dandy.
Everything fine and dandy.
Was fine and dandy.
Been doing art, trying to take the stuff off the wall to make new art put up there, like having a good time with one another.
We had a good day. Mm-hmm. It was a good day. We've had good days lately. It's been good. Like, I don't even know where this is coming from. So happy. Like, it was such a good day. I kid you not. He and I having a great day, fooling around and being stupid, but I would never do that.
But it happened, and you did.
But that's after being playful.
But no one's laughing.
And having a good day.
No one's laughing except you.
Everybody's having a good day. Oh, I'm sorry?
I would hate to see a bad day. The laughing matter.
It was fun.
Not by that
all
video.
Day. All
by
day.
That video. That
all day.
Wasn't.
Well, you said that it was funny, and you're the only one laughing.
We were playing before that.
Okay.
But then it stops.
Yeah.
It obviously stops being fun.
Well,
because you're screaming at him. He's begging to get out.
Screaming at him.
Sounds like screaming at me.
I don't know what you all want me to tell you. It was a great day.
Okay.
It didn't end well.
So you can't just try to superimpose a new image onto the situation when we haven't introduced anything, yada yada. This is a terrible argument. Not going to help anything. Why is this your first argument? Argument number 2. The trial court did not provide an adequate remedy to the appellate for the appellee's substantial discovery violation. Hard stop. No, that is Owen's fault. 100%. First, this wasn't a substantial discovery violation. Cranick said it to kind of balance out, to try to give you a little something to justify him holding a Richardson hearing as his cure for said substantial discovery violation. And what was the discovery violation? This had to deal with Dr. Tanya Warner, who was the state's forensic psychologist, her opinion about Sarah and her PTSD diagnosis, or lack thereof, because that's the whole point. The whole point is, after she interviewed Sarah, she said it doesn't matter if she does have PTSD or not. What she described to me in that 2.5-hour interview, she did not give her the symptoms, enough of the symptoms for her to confidently diagnose either way whether she has PTSD. But her ultimate opinion is, regardless of that fact, none of that matters, because on that night she said it was a good day. She never said she was triggered. She never said that she was angry. She never said anything negative at all. So even if you did have these things, it did not matter that night. That's the overall opinion. And during trial, Mr. J said something. I think the question was simple, like, have you formed an opinion on Sarah Boone having PTSD? And she said yes or no, one of those things. Either way, Owens lost his shit, decided to object, wanted to make this big whole thing, sidebar this, sidebar that, send the jury out. It's this whole thing. he can't even tell Cranick what the objection was. When I tell you Cranick was heated during this whole interaction, and in the actual breakdown of the brief, we'll go through the entire thing, but for this moment, because this is already such a huge tangent before we even get to the letter, which is the reason why we're here. So I just condensed to Cranick's highlights with a little bit from Owens and Mr. J to make it all make sense, but focusing mainly on Cranick's word because that's what they're mainly going to focus on when they're reviewing it at the appellate level. They are deferential to the trial court, trying to take into account knowing that the trial courts have to deal with a lot of things throwing at them. If they see this, which they can do because it was filmed, who do you think the courts will side with given the situation? Mr. Owens or Judge Cranick?
I understand that's what the depot reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD. So what's the legal objection? What are the legal grounds of the objection? What are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? I understand the backdrop, but the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a definitive no.
Attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said.
That doesn't mean that that's my opinion, that post-traumatic stress does not apply.
Okay, that's irrelevant for the purposes of this argument. Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens? What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
And a proffer is just to preview the testimony, being like, I'm going to literally ask her this question and she is going to give this literal answer. So there's no ambushing, calm down. But Judge Cranick says right then and there, what are you asking me to do? Because right now you're just complaining. We're not getting rid of the trial because of this stupid question. It's so dumb. Or it's teetering on if it's dumb or not. The way it's going down and the way he's handling this, absolutely. The fact that not only was this a extremely long sidebar while the jury was in there, then they sent the jury out and they still went on and on and on, and he will not nail down an argument to save his life. Or Sarah's.
Court sentences you to life in the Department of Corrections.
All right. If I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would like to have known that, and that was going to be her opinion before today.
Where is that a change in the
You're going
deposition?
to have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be? Because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. That the answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so? Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder. In the proffer?
Excuse me?
In the proffer? She's not rendering an, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not, I know I objected, I can't even remember it now, but I know I objected because I knew it was inconsistent with.
You asked to approach, and then you explained that the question was, it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but.
What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about.
specifically asked you, Mr. Owens, to point out for me excuse me.
Yeah, double homicide.
I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition.
Yeah.
87-page
Homicide. Bitch. No, I'm sorry.
And continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition as identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State 369.
369 girls wanna drink wine. Tell the man not to waste your time.
Southern 3rd, 1243. At pinpoint 1248.
248, some boys wanna hate, but you can't even contemplate.
The court is now going to conduct a discovery violation or discovery Richardson hearing. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes.
Yes, right now, because Kranick foresaw this exact moment, and he said, this is nothing, right? He could have moved on from this. This is not a substantial discovery violation because he didn't ask any form of specific question that would elicit the answer that he is allegedly taken surprise from or taken aback from, however you want to phrase it. And what is that opinion? This does not change my opinion.
That it's not related to the incident as she reported it.
And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
But Judge Kranick said, okay, fine. You're saying it's a discovery violation. You're saying that you would have wanted this opinion beforehand, that you wanted all of this, that you're being ambushed at trial, that this and that. Then, okay, here. You want to mention it all? Mention it all.
You want to mention it? Now we'll mention it.
Mention it all. Mention it all, because you know what?
Bitch.
Ask her the questions right now. Everything you wish you can ask her in this magical deposition, I, your Honorable Judge Craydaddy Kranick, will oversee this deposition right here and right now. You may proceed.
You may proceed.
Right now?
Yes.
That is going above and beyond to cure a non-prejudicial issue, even though he is saying that it could offer prejudice. But it actually doesn't, because I'm going to pause because we're going to come back to this in argument 4 in 2 seconds. But yeah, just reading that argument, I'm like, did you watch the trial? Because how could you actually watch what we just watched and then make this claim of you did not provide an adequate remedy? However, Owens never offered one. It's not like Kranick said, no, I'm not going to do what you ask. He said multiple times, what do you want me to do?
And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens? You asked to approach, and then you explained that the question was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. I specifically asked you, Mr. Owens, to point out for me I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us.
Fine, you're not going to tell me? We'll hold a deposition. You ask the questions now. You're not going to ask me if you can ask her questions. I'm just going to give it to you anyway. Do it. But anyway, now argument number 3. Erroneous jury instructions were provided on the, quote, initial aggressor exception to the self-defense rule. Because we just dug into this last one, I'm not going to really cover this one. Basically, in essence, the jury instruction was trying to argue there are exceptions to self-defense, and if you are the initial aggressor, then it's not self-defense. You can't go up and assault someone with deadly force and then claim self-defense if they react. Which, at the end of the day, didn't even happen here, right? Like, come on. So then argument 4, which is basically an extension of argument 2, but the trial court improperly allowed the admission of the appellee's expert opinion on the ultimate issue of fact. 1, this was not the ultimate issue of fact. The ultimate issue of fact is, did she knowingly leave him in there and walk away? She admitted to that immediately.
My boyfriend and I were playing last night, and I put him in a case and we were playing, and like kind of hide and seek kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase. So I don't know what happened. The problem is I fell asleep. Who zipped him up? I did, but then I fell asleep. But then I fell asleep.
Okay, you're okay. I wasn't here. I'm just trying to figure out what happened.
I fell asleep. All we had was a bottle of wine. Literally, just a bottle of wine.
Okay.
Doing puzzle artwork. Then we decided to play hide and seek. That's all that happened. Okay. So I don't know if he had a heart attack or what in there. Like, I don't know what happened. So
What time was that? Do you remember?
I mean, I know that I was in bed probably by, 12:30?
Okay.
Well, I went upstairs at least. And I fell asleep. So he thought it would be funny to be put in the suitcase. So I was like, okay, well, I'm going to joke with you, and I'll zip you up and make him, squirm a little bit, whatever it is. But then I fell asleep.
Where was the suitcase?
Right where it is.
Right down there?
Yes.
You zipped him in there?
Yes.
Thought he would be funny, a little
It
drunk.
was. We both were laughing about it.
Okay.
And then I fell asleep.
Where did you fall asleep at?
Upstairs.
In your bedroom?
Yes.
In your bedroom?
Yes.
Okay.
Totally forgetting that he was in the suitcase still.
Okay.
So he decided to get in the suitcase. So I thought it would be funny and he was laughing about it too, to dip him up in there. I go upstairs and fell asleep.
I don't think you all understand. He comes at me all the time. He comes at me. So it's either I flee or try to go upstairs and go to sleep. Well, I thought by not zipping it up all the way, it would be okay. My plan was not to leave him in the suitcase.
What was your plan?
Waiting for him to come upstairs.
And then when he did it?
I fell asleep. I would do anything for him.
Well, you gave up checking up on him. So.
Wouldn't let him out of the suitcase.
Oh, gosh.
Life in prison.
Ms. Boone, court sentences you to life. And that
Electric chair.
The end. Done. And even if that were all true, how are you so scared and terrified of self-defense that you casually go upstairs and fall asleep?
You're just sleeping in bed.
As I was last time, he doesn't like it when I sleep. I just try to avoid it, so I go to sleep.
And if you try to tie it back and say, well, I only felt comfortable going to sleep because he was confined, then you did it intentionally, and this is murder.
His tone changed, and I knew the tone, and we ended up, I guess, arguing back and forth with one another, and it was the things that he was saying very much frightened me, and cursing at me and threatening me. And
did he want you to let him out of the suitcase?
I'm sure so.
Okay. Go ahead, tell me your...
And it got very heated very quickly, and he continued to push on the suitcase. And my fear was that he was going to break out of the suitcase, knowing that it was a broken suitcase. His hand started to come through. His hand started to come through this way. And so I shook the suitcase. Trying to get his hand to go back in, shaking it, and telling him that, please stop doing this. Please stop doing this to me. Please stop doing this to me.
Did that force his hand to go back in?
No.
And were you shaking it to try to get the suitcase, his hand back in?
Yes.
How long did you shake it?
I don't know.
But his hand was still out.
Yes.
Was he trying to get out?
Forcefully, yes.
Was he angry at you?
Yes.
Were you in fear?
Always.
I have no idea. We had a good day.
Mm-hmm.
It was a good day. We've had good days lately.
Mm-hmm.
Even considering everything that's going on with our jobs and life in general and ex-wives and everything. It's been good. Like, I don't even know where this is coming from.
Like, no, I didn't pass out, I just fell asleep. So now it's kind of like, what is it? Were you guys drinking and it got out of hand and it got physical?
No.
Or is it
Drinking and it got out of hand and it got physical? No. Or is it...
Sunday was one of the better days that we have had in quite some time.
If he would have gotten out of the suitcase, what would he have done to you?
Like he used to tell me, he probably would have made me unrecognizable, or I would have lost my life.
Electric chair. Holy shit. God damn it. Electric chair.
Okay, but the whole point was, the other part of that I cut out is he point blank asked him, do you want this struck? You still haven't asked for it. I don't know what you want. Do you want me to strike her answer from the record? What does Owens do? He says, no, I'm going to use it against her and cross.
All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial, although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction?
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question, or that answer.
Okay. Then why did that... Why did you call a discovery violation, which you are saying this new ambush opinion is prejudicial to you? And then they said, okay, fine, let's get rid of the ambushed opinion. Well, no, I'm going to use it in my trial strategy against her. Okay, then what? That stuff is just so... No. And then moreover, afterwards, Cranick looks straight at Sarah Catherine Boone Paulsen herself and says, do you agree with this? Do you, Sarah Catherine Boone Paulsen, agree with Mr. Owens, your lawyer, that you should strike this testimony? Yes.
All right. Ms. Boone, court sentences you to life. Have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you.
This is a non-issue. There is no improperly allowed. And sidebar to all of this, I haven't actually read the state's response yet because I kind of wanted to wait it to go through this brief first and then get to that, so I'm sure it's explained way better over there, but this is just my reaction and summation of the arguments. And my summation is they're dumb. But he had nothing he could work with.
I'll do the best I can with what I got. Hey.
So when you hear the word discovery violation, you see what we just saw. Cranick gave them every opportunity to ask for anything. What would be the proper outcome? Who knows? So in the end, Cranick went above and beyond and did more than he had to on this issue, foreshadowing this exact moment, and that is why these arguments. Wow, pardon me, Linda, you are absolutely right. All of these arguments will fail. Okay, now after all of that, we can move on to the actual reason this video is created, and it is Sarah Catherine Boone Paulsen's letter. But before that, pause. This is where I'm supposed to tell you to like, comment, subscribe, all the good stuff. Please, please, please. Dear Sir, Madam of the 6th DCA, in my good faith efforts to abide in accordance with the order given by the DCA to not contact the courts directly and advising me to utilize my court-appointed attorney instead, in my own advocacy, I must ignore these instructions as I do not know whom else I am to turn to in this matter. Enclosed with this letter, I have included a copy of the first written communication I received from my court-appointed attorney, David Maldonado, where he clearly states he has had no intention of simply even reading the state's answer to my brief, much less respond to in my rightful opportunities to do so. His exclusive decision to relinquish his legal responsibilities limits my rights to move forward properly in my defense. Above all, Mr. Maldonado's defeating decision was made well before the state's answer was even written. This is deeply concerning, as a reply brief can only be meaningfully evaluated after proper review of the state's arguments. Yet my counsel predetermined no response would be filed regardless of what their response would be. This unconcerned approach heavily impedes and prejudices my appeal by restricting any new arguments, providing factual inaccuracies, legal misstatements, and my rights altogether. It is my understanding there are significant issues that needed to be raised and properly argued in my case, which cannot be from Mr. Maldonado prematurely surrendering his duties as my defense counsel. This approach also raises legitimate questions as to the level of professional diligence, effort, and careful consideration devoted to the successful preparation of my initial brief as a whole, if counsel had already decided before seeing the opposing party's position that no additional advocacy was necessary. Was that a sentence? I have done everything I know how and have the resources for to consistently attempt to work with, rely on, and be included by my appellate attorney as the court would expect. Due to Mr. Maldonado making clear his position in the written refusal to act any further on my behalf has forced me in my responsibility, right, and as a party also in the justice system, being the appellant, to make the court aware of my critical situation. In all respect due, I ask for understanding in my direct contact and graciously seeking guidance from the 6th DCA in this matter. Sincerely, Sarah Boone. Well, there is our good old-fashioned Sarah in full form, back in her criminal trial, giving the exact same thing she has always given. Nothing. Just complaints. I am graciously and respectfully asking for your guidance. You know, the last time you gave me guidance was an order telling me not to do this, and I just ignored that anyway, but I'm asking for more guidance. No, you're asking for actions against Mr. Maldonado, and you need to amp everything up again and again in order to manipulate and force him into doing what you want him to do. So him not dragging this out further means he's refusing to represent you, relinquishing your rights, avoiding his legal duties, this and that. But don't worry, she's only doing all of this because she's in such a critical situation. And what is the critical situation? I disagree with the decision he has chosen to make. And that's why attaching that email is ridiculous. From everything we just covered, I know it took forever at the beginning of this video, but that's just to contextualize how absurd and ridiculous this letter is. The appeal is already dead in the water. You're not going to get a new trial from this. He knows this. He has actual cases that he could win and is being paid for. But Sarah requires everyone to maintain the delusion that she lives, and if you aren't doing every single little step you can to represent her, then you are abandoning her and not representing her whatsoever. So then she has to do it herself. But she doesn't want to do it, she's forced to do it, and then if you make her do it, then
sometimes I'll start a sentence, and I don't even know where it's going. I just hope I find it along the way.
It's just a never-ending cycle of ridiculousness. Because then she'll go back to Mr. Maldonado and say, well, I'm sorry you forced my hand and made me write that letter to them, but now maybe you'll listen, right? And then he doesn't, and then she has to do this again and again. No. It's just funny because the last time she submitted this notice of inquiry, they nullified it saying you are being represented. Appellant Sarah Boone, and files her notice of inquiry with both the 6th District Court of Appeal and Orange County Clerk of Court, stating the following in support of. 1. After appellant's first court-appointed appellant attorney, Alan Holland, December 2nd, 2024 to February 18th, 2025, was granted his motion to withdraw, Joshua E. Adams was appointed by the court to represent her and submit the initial brief in and for her criminal appeal. 2. During Mr. Adams' time frame of 7 months, February 18th, 2025 to September 5th, 2025, in his representation of Miss Boone, which includes filing two extensions to continue doing so, he made the decision to withdraw without submitting her initial brief, citing he is no longer practicing appellate work or accepting court-appointed appellate cases. 3. Joshua E. Adams corresponded with appellant in one public access tablet message on February 27, 2025, briefly introducing himself with no follow-up or continued contact to present date. 4. As of the date of this filing, appellant has no understanding of whom her present appellant attorney is, the current status of her appeal, nor the preparation of her initial brief as a result of no communication or inclusion from any party, including both the 6th District Court of Appeal and or the Orange County Clerk of Court. Wherefore, appellant Sarah Boone respectfully files this notice of inquiry to request pertinent information regarding the updated name, contact phone, and address of the successor court-appointed counsel to represent her and the status of her appeal, including the filing of the initial brief in this manner. Submitted this 27th day of October, 2025. Amended order appointing counsel. The court, upon reviewing the court file in the instant case, hereby finds as follows. 1. The court appointed David Maldonado, JD, to represent the defendant appellate Sarah Boone in this case for purposes of her appeal September 12, 2025. 2. A certified conflict arose that would prevent the regional counsel's office from representing the appellant pursuant to Section 27.40 of the Florida statutes. 3. As a result of the conflict, it was necessary to appoint private counsel for the appellant. Wherefore, it is ordered as follows. A. The court's prior order appointing counsel dated September 12, 2025 is amended to reflect that a certified conflict arose that would have prevented the regional counsel's office from representing the appellant in the case, and therefore necessitated the appointment of David Maldonado, JD, as counsel for the appellant. B. This court reserves jurisdiction for the entry of such future orders as may be necessary. Done and ordered at the Orange County Courthouse, Orlando, Florida, this 4th day of November 2025. The Honorable Michael Kranick. By order of the court, Attorney David Maldonado is counsel of record for appellant. Because appellant is represented by counsel in this case, the motion filed pro se and docketed November 20th, 2025 is stricken as a nullity. See Logan v. State, I hereby certify that the foregoing is a true copy of the original court order. Unless you submit a letter to them saying, I am firing Mr. Maldonado, they're not going to take this seriously. Unless it is something that major, you are not to jump over your legal representative. He is representing you. I know you want to be a team so bad. I don't know where you got this misconception that the legal system is a team effort. Probably the misconceptions of all the time she got George arrested just gave her this inflated sense of ego and belief that she can control the legal system into doing whatever she wants.
I don't want to get in trouble.
Why are you getting in trouble? If he contacts you.
I got in trouble last time.
One last
I gotta
time.
take my son to school tomorrow. Sleep in my bed. It's not fair. Remove him, please.
Sarah, I'm going to do my job. Don't worry about that. What I want to know is why you're not doing your part in all of this.
I have to. He's here. Yeah, you can stay right here. You can stay right here. He doesn't know that you call. He doesn't know how to know it.
You're a cheating, lying scumbag. I will never trust you. Why don't you put your mugshot up? Or I will, since I have your phone, and log in and tell everyone why you're in jail for the 3rd time. Let them know you beat your wife and she put you there because she couldn't take it anymore.
Babe, I had no idea.
Jesus Christ.
Babe!
Stop screaming at him. No. Go back inside.
Sure!
Go back inside. Go back inside. Jesus.
Do you need Jesus right now?
I don't. Just go inside and call Mom and Pop.
How's Henry over there talking to him?
Henry's the property manager. Why is this
What do you want me to do?
Ma'am,
I got both. Hold up, wait a minute. Y'all gotta go. Okay, it's done when it's done.
Why are you screaming for?
You need anything with me?
I need you to go inside like the past 5 minutes. Goodness gracious. All right, go.
George! I'm not getting arrested.
No, I'm getting a statement from you. You're not being arrested. So,
Okay, look, I'll come over and see you in like 5.
Come on.
Thanks, buddies. They know.
Let's get this done.
They know.
Okay. Now, would you come in here so we can do your statement, please? And stop this.
As long as she tells the right sob story and says that I'm being abused in every way imaginable, they will eventually give in. And she can't believe to this day they still haven't. All right, now let's rewind this and do it line by line. Dear Sir, Madam of the 6th DCA, in my good faith efforts to abide in accordance with the order given by the DCA to not contact the courts directly and advising me to utilize my court-appointed attorney instead, in my own advocacy, I must ignore these instructions, as I do not know whom else I am to turn to in this matter. Enclosed with this letter, I have included a copy of the first written communication I received from my court-appointed attorney, David Maldonado, where he clearly states he has had no intention of simply even reading the state's answer to my brief, much less respond to in my rightful opportunities to do so. And this is why we went through the email first, because nowhere in there does he ever, quote, clearly state he will not read the state's answer. He's saying that he is not going to send a reply brief. There's a difference. As far as what to expect next on the appeal, the state will have an opportunity to file an answer, and the matter will then go before the appellate court for review based on the brief submitted. I will not be filing any reply brief and also will not be scheduling any oral argument, as I do not believe it is necessary in this matter. And oral arguments are generally not granted on these matters anyway from the appellate courts. The fact that you are telling judges, some of the highest courts in all the land, this is clearly stated that he is giving up when he is just not giving in to your demands. But it'll never, I won't get over this. The whole reason I wouldn't even have covered this letter if it wasn't for this first line of, in my good faith efforts to listen to what you told me, but in my own advocacy, which is more important than a court order.
But because he had violated the pretrial diversion, this time it's probation, so you don't have a choice in it. You have to go to see your probation officer. You have to go to these classes. It's court ordered. Where it took him a while to get used to it and understand, they're not messing around.
Court ordered. Where it took him a while to get used to it and understand, they're not messing around.
Which is ironic because to this day, she still hasn't figured out that the court system is not playing around with her. She still thinks this is all a game, which is why it's so funny. You tried to put George in this situation time and time again.
If anything else shows up, you can go take that paper down to headquarters.
It's not getting anything else because she's taking him down.
I
Put
mean,
him under the jail.
He's going.
Under the jail.
It's not getting anything else because she's taking him down. Put him under the jail. He's going under the jail.
Okay.
Why? Because you wanted him to listen and behave himself. How do you think this is not going to catch up to you? How do you think the courts aren't being serious? I think she's like, well, if I'm already so low, I can't dig myself any deeper. And then somehow she finds a way to dig herself deeper and loses even more privileges. And they'll definitely strike this in the end. But the next step is to tell the clerk, do not accept any more pro se filings from Sarah Catherine Boone Paulsen.
Excuse me, you're eating my peach.
We only want communication from Mr. Maldonado. And this letter actually confirms and solidifies that decision even more. That's what she does all the time. Anytime anyone gives her a restriction and says she shouldn't do something she wanted to do, she'll do it anyway and be rude about it, just giving them ammunition to the reason why they shouldn't have given it to you to begin with. But she must lose all of these privileges until she finally understands they're not messing around.
They're not messing around.
So I must ignore your direct orders and rules and expectations in order to say my piece one more time, to advocate for myself one more time. Why? Because it is my legal and rightful opportunity. Just because it is an option that is available does not mean it is an entitled right. No one is entitled to a reply brief, and oftentimes it can do more harm than good. Especially in cases like this where the only winning strategy is to get them to look as far away from the facts as possible. You do not want to keep going down this road to where Mr. J can drag you through the mud again and again and again. But when she comes out the gate with such a huge, massive claim and admittance of fault of, thank you. Linda had to speak her truth on it, and I completely agree with it. She opens with this huge claim that she knows she's breaking the rules, so to justify it, the rest of this letter has to amp everything up. Don't worry, I'm not just breaking the rules because I'm annoyed and because he's not doing what I say. I'm doing it because he's abandoning me, and in my own advocacy, I must ignore whatever you tell me to do until you do what I tell you to do. And then we hear, in my first written communication. What is that supposed to mean? In the quote, your first written communication, he says, in our previous phone call. With respect to the phone call, and as I made aware during our last call, I ordinarily do not call inmate appeal clients on court-appointed cases, as I prefer written communication. I simply do not have the time or resources on this case to schedule yet another call to discuss the brief, as the brief is self-explanatory, and I made the best arguments I could on this case in light of all the circumstances. How did you set up a previous phone call if there wasn't written communication? Did he come by the jail and talk to you? Did he schedule a video call? How did he meet with you? But she did this with Mr. Bankowitz all the time of moving the goalpost. He hasn't called me in so many times. We only had video messages. We didn't have productive meetings. Frank J. Bankowitz has been appointed as my attorney by the court. Total approximate hours of representation, 7,200. Total times attorney met with client Sarah Boone, 6. Phone numbers given to client by attorney, 2. Phone calls answered from client by attorney, 0. Outside sources calling attorney on behalf of client, 3. Letters client sent to attorney trying to communicate, 7. Letters defendant client sent to judge trying to communicate, animate attorney in unsuccessfulness, 5. 15-minute video visits between attorney and client, 3. Attended court dates scheduled, 2. I was an attempted withdrawal. The other an allowance to finally be included in my PTC, which was the same information carried over from the others. Now what? 4. Our agreement made from one of my letters I wrote earlier this year after not hearing from you in a solid 5 months prior was to connect every 2 weeks with or without any significant progress. Oh, no. That is crazy work. 7/11/23, 12 months, 365 days, 52 weeks summarized, 8 total months, 240 days and counting. Are with absolutely no communication in any form, completely inactive. Total amount of hours as court-appointed attorney, over 8,760. Total times met with client, me, 6. Total hours spent with client, 7. Total phone numbers given to client from attorney, 2. Numbers that work, 0. Total time speaking to client via phone, 0. Total number of 15-minute video visits with client, 4. Total number of letters sent to attorney trying to communicate, 8. So her nebulous communication goals always extend and always are not being met. Because you aren't talking to her physically enough, you aren't writing to her enough, you aren't calling with her enough, and if you are not speaking to her through every form and method of communication imaginable, then you are ignoring her completely and not communicating with her at all. Writing down the first written communication was supposed to make it seem like he hadn't talked to you, but coming straight out the gate, he says, we've had a prior phone call. I'm not scheduling another one to go over the exact same thing with you. The brief has been submitted. It's not changing. And this is just that repeated pattern again. She wants to do anything to disparage her attorneys in order to force the actions she wants taken. And she blatantly admits it in that letter, saying, I've written all these letters to the judge so that the judge would tell my lawyer to talk to me. Total number of letters to the judge trying to communicate my unsuccessful communication with my attorney in hopes he will communicate with him to communicate with me, 7. Where is the progress after one entire complete year? Unknown. So dumb. His exclusive decision to relinquish his legal responsibilities limits my rights to move forward properly in my defense. Above all, Mr. Maldonado's defeating decision was made well before the state's answer was even written. This is deeply concerning, as a reply brief can only be meaningfully evaluated after proper review of the state's arguments. Yet my counsel predetermined no response would be filed regardless of what their response would be. This unconcerned approach heavily impedes and prejudices my appeal by restricting any new arguments, providing factual inaccuracies, legal misstatements, and my rights altogether. It is my understanding there are significant issues that needed to be raised and properly argued in my case, which cannot be from Mr. Maldonado prematurely surrendering his duties as my defense counsel. Your understanding is wrong, and this just proves it more and more and more. This is like she has a complete misunderstanding of what a reply brief is. Of course, it restricts any new arguments because you're not supposed to be making any new arguments. You're not supposed to be providing factual inaccuracies in regards to the case as a whole. A reply brief is replying to the state's answers. It is not yet another opportunity to advance more lies and make more arguments. And that's the biggest misconception with Sarah in the legal system as a whole. And I've mentioned this before, but she thinks this is all a running conversation, that it never ends. As long as I get one more opportunity, I have another chance to speak and say more and more. And that's even shown in the family court trial, where at the very end, Your Honorable Judge Jackson is saying, is there anything else? No, Your Honor, that's all I have for right now.
Next piece of evidence that you want to, next exhibit that you want to admit into evidence. Anything else?
I think we're missing one because I haven't put in the JPEG communication. I put in the GCL communication, but not the JPEG.
We have number 35 admitted into evidence as number 8. Number 37 admitted into evidence as number 9. Next.
Number 36.
All right, we're receiving to evidence what was pre-marked as 36 as respondent's exhibit number 10, which is also a letter. Next.
That's all I have for right now, Your Honor. I'm being rushed out.
That's all I have for right now, Your Honor. I'm being rushed out.
I'm being rushed out. What do you mean right now? There's no more anything after this. This is a final hearing. That's what I have for right now. She thinks the conversation never ends, which is why she sends the letter to the judge afterwards, which is why she sends the letter again after sending the letter again, which is why she's sending this letter again after sending the notice of the inquiry, after sending the other letter again.
Sometimes I'll start a sentence, and I don't even know where it's going. I just find it away.
At a certain point, she has to have all of her privileges taken away. And she probably thought that she wanted him to give oral arguments so that she could be there and testify. No, she is not going to say a word in this entire appeal because it is not about her subjective opinion on anything. It is about what the record shows, what the record reflects, and what the record can prove. That's it. You don't get infinite amount of time to keep adding and adding. At a certain point, it has to end. And this is that end point. He said, I'm not doing a reply brief because I made the best arguments I could. The state's response is only responding to the arguments made. And a reply brief is only responding to that answer, saying, this is what they got wrong in their answer. No, Owens didn't make a complete fool out of himself in this one hearing, and now I have to try to stretch this discovery violation to make it big enough to get a whole new trial. He can't prove that the state is lying about any of that, because they aren't, because it's filmed, because everything Sarah does is filmed. But just even more overly inflated language, his exclusive decision to relinquish his legal responsibilities limits my rights to move forwards properly in my defense. How do you know? All you do is complain, saying, I've never done this before. I don't know what I'm doing. I'm not a lawyer. I need help. Please, God, send me a lawyer. I'll do anything if you just give me a lawyer.
I'll trade in my life. Do you understand? Listen, I will trade in my life for the rest of it. Whatever I need to do, please, God, see if you can get me an attorney. Just please. I feel like I want to throw up. You don't understand how overwhelming this is, that I can't keep up with it and I can't properly defend myself. And if this is my only opportunity, then I feel like I'm going to fail. It's too much information for me to be able to understand and be able to convey properly. And nonetheless, I'm not an attorney either. So, I don't know how I'm supposed to justify any of this when I don't even know what I'm talking about other than what you typed out on the tablet for me.
Can you bring paperwork in there?
Yes.
Okay, good. Okay. So, can you bring your tablet?
I'm hoping so. I'm going to bring it with me anyway.
No one knows how to do anything properly. She has never had one proper attorney, just so we're clear. Out of 6 years, multiple trials, different occasions, different circumstances, different genders, ages, nationalities, races, classes, well, maybe no. But lawyers of all shapes and sizes have all failed her, have all been prejudiced against her. It's always been them attacking her. She's not responsible for any of it.
I have prepared this for you. It's a letter and then a continuation of the letter from the video visit, sir, you are aware of, and everyone constantly blames me that I am the reason why I am supposedly on attorney number 8, which I am not the reason for any of them.
Which I am not the reason for any of them.
If there's the same common denominator, there's the same common issue. At no point does he ever say, I am no longer going to do any work on your appellate case. He said specifically, I will not do these 2 things. Because she fails to realize that stretching this out further makes you look less and less credible. She believes that fighting tooth and nail until the very end will show everyone she's telling the truth, that she means business. That's why she always says, I want you to see my heartfelt effort, my determination to be included in my case. That's not why we're here. The case isn't won off of who's trying to be included. It's won off of the merits of the case alone. And that is what she tries to step around and avoid at every single turn. Above all, his defeating decision was made before the state's answer was even written. Reply brief only reasonably be evaluated after proper review of the state's arguments. Now, this is like the strongest point she has here. Yes, he should not have told her, I'm not going to submit a reply brief or ask for oral arguments, and the state's answer hasn't even been posted yet. He could have said, I don't intend to make a reply brief. I will read the state's answer and we'll go from there, but oral arguments are normally not granted in this case, and I do not think a reply brief is necessary. That's how you should normally handle it. However, for Sarah Catherine Boone Paulsen, if you leave a crack in that door, she will try to bust it wide open when she gets a chance. So you have to set the firm boundary of, this is not happening. Move on. Get over it. But it's that framing of his defeating decision. She does this a lot too, where she believes that if she predicts the obvious outcome and says it out loud, then we're supposed to counter that narrative and say, no, just wait. We'll wait and see. So that any outcome that aligns with this, quote, defeating decision, the only plausible outcome from the beginning, means that only happened because of this. So if I lose my appeal, it's because he made the defeating decision. That's the decision that defeated me, to not make a reply brief, to not make more arguments that she wanted to make that you're not allowed to make in an appeal, which is just supported more and more in the family court trial when she kept saying, the reason why I've been in here for 5 years is because I keep fighting for my case and to prove my innocence.
Like part of his daily life, and for him to take that away from me is just out of bitterness and spite. I want to be a part of my son's life. And people forget that I have a pending appeal. So to prove my innocence, which is what I've been doing since day one, the reason why I was incarcerated in Orange County for over 5 years, or at least 5 years, was because I continued to fight for my case.
And it's like, no, everyone is telling you to stop dragging this out, that you will be more persuasive, that you will be taken more seriously, and that you'll be seen as less of a horrible person if you stop wasting everyone's time, efforts, resources on stupid surface level stuff. I simply do not have the time or resources on this case to schedule yet another call to discuss the brief, as the brief is self-explanatory, and I made the best arguments I could on this case in light of all the circumstances. I get it, it's not stupid to you because it is your life. However, you refuse to accept your situation, and you keep trying to gaslight the world into believing this delusion. That doesn't make sense.
The amount of attorney's fees that Mr. Boone has incurred to fix basically all the chaos that occurred due to Miss Boone's voluntary act, criminal act, and also her ongoing defiance and unwillingness to acknowledge the reality of her situation and the reality of this family's situation.
And so the world is continuing to abuse you again and again because they are not giving into your delusions. And until they do that, everyone's against you. It's unfair. Woe is me. Poor baby. Boy crying wolf.
I can't breathe.
George has done that in the past before too, where it's just like he thinks that he's woe is me kind of thing, where it's like
He's never been locked in a suitcase. That's where he couldn't get out. So
it's kind of, I thought it was
and
the
you
boy
know the oxygen
crying wolf kind of thing. I thought he was okay. Like I didn't.
He's telling you he's not. He's telling you, Sarah, I can't breathe. He's saying your name, and you're like, that's my name. Don't wear it out. Regardless of how long you were there, you left. You say, I
thought he was the boy calling wolf. Again.
You're like,
again, it's the boy calling wolf.
Okay, but where does this game end? You say this is a game, you got somebody in
obviously,
there.
like the wrong way.
When somebody's begging saying, I
But
can't
when you
breathe.
say that though, but you have to, y'all
Please let me out, I can't breathe.
don't know George though. Like that, again, I thought it was the boy crying wolf. So it's just like, what? Oh, so if
But more accurately, it is the wolf who cried wolf.
it's kind of, I thought it was wolf, crying wolf kind of thing.
You say,
I thought he was the wolf, calling wolf. Again.
You're like,
Again, it's the wolf calling wolf. Again, I thought it was the wolf crying wolf. So it's just like, what? Oh, so if
Because all she does is call, cry, complain, saying, I'm abused, I'm being murdered, my rights are being taken away, come help me, come help me, come help me. And every time they come to your aid, they realize you're the abuser and you're the one who needs to be locked up.
To life in the Department of Corrections with credit time served that Madam Clerk will provide to you momentarily.
This approach also raises legitimate questions as to the level of professional diligence, effort, and careful consideration devoted to the successful preparation of my initial brief as a whole, if counsel had already decided before seeing the opposing party's position that no additional advocacy was necessary. Was that a sentence? Barely. It is an exercise in how much manipulation you can push into one sentence. Because it's wild. Raising legitimate questions, what makes them legitimate? Merely the fact that she says they're legitimate. What are the questions? She won't tell you. But it's only used there to reform it not as an accusation. I'm just asking questions. I'm not accusing you of not being professionally diligent, not putting forth any effort, not putting forth any careful consideration, not being devoted to the successful preparation of my initial brief. No, I'm just asking questions. Now, I will say, to be fair to Sarah, there are actual concerns to the preparedness, or at least to the polish of the brief he submitted. First and foremost, he put the wrong county on the cover page. I was like, wait, what? And then I put it in the GPS, and Polk County is an hour and a half away. Sir, you can at least look at the first page to make sure that you are putting Orange County where this case is taking place. But mistypes happen. I imagine that's his standard cover letter. You know what, Linda, you're right. It shouldn't matter if that's his standards or not. You should actually just look through, or at least have a paralegal go through and make sure everything looks correct. But typos are bound to happen. Not that big a deal. However, in this case, you get the level of diligence you deserve. Kranig did such a great job of making this airtight, tying all loose ends, going above and beyond, because that's what Sarah requires. You're not being professionally diligent or putting in enough effort unless you are constantly doing something. If there is something that you could be doing and you are not doing, that means you are not being professionally diligent. You're not putting in careful consideration. She always thinks people need to care, which is why she didn't have a family court lawyer, because she scared off everyone she talked to. And she said, well, she sighed, and I just felt like she didn't care.
Okay, we had an attorney prepared to come and defend us. For whatever reason, she has a conversation with you, and now she's gone. Because for whatever reason, she didn't get a sense from you that she wanted to work and fight for you.
Think that's me? Do you think that that's me? Think that's me? Do you think that that's me? And I said something?
No,
I told you she sighed the entire time.
That's what we have to change. Because we want her, who gives a fuck if she sighs?
Because that means that she doesn't care enough.
We have to wipe that.
Care enough. But that doesn't, I got the vibe she didn't care enough. That's why I was like, why?
Girl, you are broke.
With your broke ass.
They don't have to care about you or not. You need someone to help defend you. You shouldn't care about that at all. But she does. And that's what she said about all her lawyers. It seems like they don't care enough, they don't believe in me, and they have a defeating attitude. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box, where there is no privacy whatsoever, and held in an open bay dorm with more than 62 other interested all-ears inmates. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. As always, my attorney did not listen nor care after I repeatedly tried reminding her of my unsecure environment, barking at me, I can listen or not. Still going, over speaking, and not at all allowing me to respond. After repeating to her over and over and over, while she's beginning to speak louder and over me still, to please schedule an in-person meeting where all can be discussed further, privately, with no success of being heard, I disconnected the visit telephonically. She, uncooperatively. She is impossible. See previous letter or ask her for a copy of the 2 I sent her. I was trying to remedy or lessen before sending this to you. Your honor. And not having to include. Now it's a race to the pulpit. My question, please, who acts like that and still be able to call themselves professional? The visitation box is primarily for family and friends to connect. And if a must for an attorney, reminder notices, quick questions, not high-level confidential case information. She, like other former attorneys who always blame their dysfunctions on me, said, you don't like the answers I give you. What answers? See pages 1, 2, and 3. I am not the problem, except I want to and should be treated fairly, with respect, acting more professional than the paid. I've been doing this for over 40 years, professional. After so long and in all the experience, common courtesy, customer service, and listening skills should have been acquired. All attorneys. Do you remember why you even wanted to be one? Remind yourself. No one listens, and it works for everyone's favor but mine. That I am a murderer, stuck in jail so they can pin on me. They're uninterested, unmotivated, hopeless. They're going to believe me over her haughty attitude. I am not wrong for not thinking less of myself, because everyone else has and does. This present attorney foremost.
It's things that she likes to tell me is not necessary, but I know for a fact it is necessary. She likes to, in quotes, put things to rest all the time and constantly tells me I'm not having this conversation with you. So I'm not going to waste my time, and I, being in jail, have supposedly abundant amounts of. She's not going to waste my time because she's not going to explain something to me. And I have taken it upon myself to explain it to myself because she refuses to do so. I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate, and I try very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she's supposedly representing my life. She is untruthful with me and full-blown prejudice against me, which I believe adds to her nasty attitude towards me, and I do not trust her. So I have prepared this for you. It's a letter and then a continuation of the letter from the video visit, so you are aware of, and everyone constantly blames me that I am the reason why I am supposedly on attorney number 8, which I am not the reason for any of them. I put this in here also so you are aware. Again, I refuse to be mistreated by her as my attorney. I'm shocked that she has a proposed trial date, considering the fact that I have not seen anything.
No, they have a realistic attitude about the situation you refuse to accept. So you berate them for not joining you in the fantasy, which is underscored by the word devoted to the successful preparation. No lawyer can ever promise you success. And if they do, they're lying, they're scamming you, and you're probably going to lose the case. Because innocent people are found guilty all the time, and guilty people are set free. Regardless of the strength of the case, at the end of the day, you can't control what a jury or a judge is going to do. You can just put your best case forward and hope for the best. But she is obsessed with the word success, and she weaponizes that word success, waving it around saying, I'm only asking for this because I'm looking for a successful outcome. That's the only reason.
Social media has made me a pariah. It has caused great oppression and undeniable disadvantages, especially by broadcasting and manipulating my cases online. In my criminal case, as a result, my opportunities to be given a fair, proper, and uninfluenced, successful conclusion was heavily depleted and poisoned. I forgive them. If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case and the successful outcome that they were hoping for by being provided simply papers and pens.
Counselor, if you...
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
Don't you all get it? I'm looking for it. Yeah, we do get it. But you're a murderer. People aren't trying to fight to give you a successful outcome just because you still see yourself as an angel and as a good person.
Good person.
Great person.
Angel. Best thing that has ever happened to you.
Yes, ma'am.
The facts state otherwise. But the underlying support of this is saying all of these accusations, I'm saying he's not putting in enough effort, it's only because he already decided before seeing the opposing party's positions that no additional advocacy was necessary. Doing another reply brief doesn't inherently mean additional advocacy. It could detract from your case if you open more holes. The reply brief is only replying to the state's response, which is only replying to the appellant's original appeal brief. So all the main arguments are already put out, set in stone. Your reply brief would just be to say whether their answers are accurate or not. And he knew before even submitting this that these issues are so easily fact-checkable that there's going to be nothing to reply to. Yes, the state is going to do its due diligence, and they did through a 45-page answer, and meticulously break down every single argument. and I'm not going to take the time to try to reply to it when I'm going to lose anyway. That's also why he's not doing oral arguments. These issues aren't nuanced enough to where a judge needs to hear oral arguments. That's the only times they're really going to request that or grant that. But if you didn't put in the motion, then you didn't put in effort, which is why Owens was forced to drink the Kool-Aid. He was forced to put in motions that are ridiculous, that no other clients have probably asked for. Makeup and hair.
If you could get it to her. So that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, we would like, she would like for us to have some makeup for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay.
Snacks.
As my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning, and then of course she's brought up around 9, and then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stopped allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one. She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch. But she's not diagnosed with any kind of blood sugar.
She's not diagnosed with any kind of blood sugar.
But she says she gets, like today, she's feeling tired and lethargic, and so she feels like those items during a break, that she could have something like that to keep her energy level. I'm asking for the court's permission that she be allowed to do that.
My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. And that's for all inmates that are stored downstairs during trials. So I'll inquire of the jail staff if I can get a hold of them this evening, and hopefully have an answer, if any, tomorrow.
This woman is on trial accused of committing a murder, and she's concerned about her snacks. Snacks.
Unchained, unshackled, original, tailored outfits, new clothes.
Getting clothing for Boone during the trial, how was that?
Yeah, so as you might remember, the trial did start jury selection last week before it was delayed midway. And there was a delay there because Sarah Boone can get her clothes. Now, this is important because her attorney doesn't want potential jurors to see her in that jail jumpsuit. They want her to be seen in normal clothes. So today she actually came out with the same outfit and jail slippers, as I mentioned.
Oh my God. Only you would think that you could hide that powder blue, puffy sleeved, it's kind of a peasant dress, but it might just be a baggy disaster of questionable fiber content that you wore to the spring dance. Lizzie McGuire, you are an outfit repeater.
There's been an issue with getting her clothes. That was one of the big topics that her attorney spoke with the judge today, and they said that they seem to have worked that out.
And she wants to sit at counsel table looking just like one of the lawyers. So on a certain front, congrats to her for asking and getting that much. That's why she does this, because they do give in to little things, because at the end of the day, the big things will not pan out. This is the big thing. They gave you those little things. They gave you this and that because they knew at the end of the day, when you got here, the door was going to close on you, as it should. And even after doing all of that, she still says Owens didn't represent her properly, didn't do enough, didn't care enough, yada, yada, yada. There's literally nothing anyone can do to please her, so there's no use in trying, which is what Mr. Maldonado learned early. I have done everything I know how and have the resources for to consistently attempt to work with, rely on, and be included by my appellate attorney as the court would expect. Due to Mr. Maldonado making clear his position in the written refusal to act any further on my behalf has forced me in my responsibility, right, and as a party also in the justice system, being the appellant, to make the court aware of my critical situation. In all respect due, I ask for understanding in my direct contact and graciously seeking guidance from the 6th DCA in this matter. Sincerely, Sarah Boone. Well, if this were actually in all respect due, you wouldn't be sending this letter because you would be respecting their earlier wishes, which were to communicate through your lawyer. But it's okay, because you have to understand, of course I would have paid attention. I would listen to your orders no matter what. He is forcing me to do this. It's just that same abusive pattern again and again. You harass Brian, he's forcing you to call him relentlessly every single day. Active decision not to. We don't have to talk to each other. It's one time to just get me what I need and can have. You make it a million. Do you really want me in your life so much to make me contact you every day, every day, every day? I ask as many times as needed to finally get an answer. If not this way, which would be more simplistic and less time consuming, especially for you and then in court, where you can answer everything when the judge asks you or orders you to answer. Don't you think? The reason for a very needed court date is simply over you not cooperating. You understand that, right? Then with all my paperwork, messages, requests, concerns, questions, etc., I'm going to submit. Everyone will see it. It's simply you taking up everyone's time. You. So simple. Please be part of the solution this year, not the problem. Which, according to a new video by Tanika's 2 cents about her jail logs, Sarah is yet again, and we already knew this was going to happen, the problem, and already going against the judge's family court order of 1 30-minute phone call a week unless agreed upon by the parties. The video, and it's just her berating the son again and again and again, and him not answering again and again. And then I saw a comment on one of my posts, and this person had also watched Tanika's video and said that she had called her son 47 times in the month of April when she got the final judgment. She does not give a damn about a court order. She's going to do what she wants to do anyway. If the court tells her specifically, stop contacting your son, stop contacting us, she's gonna do it anyway. So I think it's safe to say this will not be the last letter, of course. George forced you to abuse him, call the police on him, beat him, and murder him. Your lawyers forced you to go to the judges again and again because they would not meet the expectations you demanded. She always manipulates her choices and actions as forced reactions. No one made her write this letter. No one got the pen and paper for her, sat her down and said, write this down. I'm forcing you to send this to the court right now. She made choices. Choice after choice after choice after choice, and somehow it is your fault for not figuring it out. It's your fault, George, for not using your 2 little fingers and opening it with just 1 finger, because that's what she did. I mean, it's just lie on top of lie. But it is no responsibility for any choice she has ever made. She has only made bad choices because of you. Saying I have done everything I know how to do and with my resources to consistently work with, rely on, and be included by my appellate attorney. Consistently work with. There's no consistent work to do in appellate work. There's a lot of waiting, a lot of drafting, a lot of reading. You can't do any of that. Rely on, be included. Be included in which way? She wants to make the legal decisions, but also it's how she would talk to Mr. Bankowitz when she was wondering, where are you? You said you had all this stuff that you were organizing. Have you been able to organize it? I could help you organize it if not. 5. Discovery case materials. In the status hearing, you stated you have 2 boxes of information that are out of order and unorganized? Have you organized and reviewed? How long have they been in your possession? When will we be going over? It is extremely concerning. This is all you have. It has been said there were 3, 5, 6, a ton from some of the attorneys prior on my case. Which is it? And what is there? 3 years later, I'm still wondering. I have also put in numerous hours, pages, pen ink of my own information, which I'm praying is in either of the boxes you currently have. Please let me know, as the added amount of even more time to locate, receive, review anything missing from everyone receiving before and withdrawing will most definitely be extreme. I don't know what you have. I also could assist in organizing what you do have, considering it's all part of my case. I am eagerly waiting and more than willing to help with this and everything else. I just need to see what there is, and which I have yet to 3 years later. That's what she means by included. A member of the team, someone who is working side by side. They're up late at nights. There's all these sticky notes all over the place. Boards with thumbtacks and strings flying all over the place on somehow how to make this losing case make sense.
Every day, Pepe's mail's getting sent back to me. Pepe Sylvia, Pepe Sylvia. I look in the mail. Well, this whole box is Pepe Sylvia.
And even if she got that, she would be annoyed because it wasn't productive enough. And what does productive mean? It means you have to believe her story to the T and do every single thing she says, or you abandoned her and you did nothing. And that's how he was making it clear in his, quote, written refusal to act any further on my behalf. Just major inflation. He said the only thing I'm not doing is the reply brief. He didn't say he wasn't going to do actions moving forward. If judges come back and issue orders and ask him to do things, he's going to do it. He never said, I'm done. If the court asks me to do anything, I'm not going to be there. I'm not going to do any of the things I have to do after the decision comes out. You're on your own. But she thinks she can push that and project that onto him, which she shot that down when she attached his actual email. If she just sent it as is, she could make up whatever he wanted to say. And then he could say, here's my actual email. I mean, he can't because it's client-attorney privilege. Again, she's just waiving her rights all the time. You want to talk about your responsibility, your rights? How about you maintain that attorney-client privilege and not just air out all your business? And that's how Nicole's full name is now out there in the world. You did that. Your attorney didn't upload this. Your attorney didn't send this. You could have even marked it out, like literally just draw lines through it or whatever before you scanned it and had it sent with this letter. But no. You wanted it the way you wanted it, and you aired her out. Now you made her a target. I hope not. Please, people, leave her alone. Sarah abuses her enough already. But again, just the compounding has forced me in my responsibility, my right as a party, also in the justice system, being the appellate to make the court aware of my critical situation. Does not define said critical situation. What is critical? What is the situation? Is it I'm running out of time to submit my reply brief, and now it is critical that I get that in time? You didn't say that. You know what else you didn't say? You didn't ask for literally anything. What is this supposed to do? This is what Judge Wooten would keep telling you, saying, I read all your letters, and it depends on what I'm asked to do in the letters.
Ms. Boone, I read your letter dated August 26, 2023, and your letter dated August 30th, 2023. And just so we're clear, I read all of the letters that you send to the court. Whether I respond or not is based on what's in the letter and whether I'm asked to actually do something that's within my purview as a judge or not.
You don't ask for anything. You complain and then ask for, quote, understanding and guidance. That is not what judges are there to do. How's judge supposed to put in an order, guidance, and understanding? No, you ask him, I want you to compel my attorney to write a reply brief or allow me to submit one pro se. She would never do that. Yeah, if it's that important to you, you write it.
Since you got your degree and you know every fucking thing.
But no, she's the type of person to say, here's all the issues I have in my life, and now I'm going to make it your fault. And if you don't do anything, you didn't help me. But yeah, that was this whole letter. She never asked for remedy or anything, no relief. She only asked for validation. I want you to validate my opinion that my lawyer's a piece of shit, so that I can go to him and say, look, you're a piece of shit, and the judge agreed with me. That's also how she does all that phrasing with the, oh, I almost forgot, what was it? Be included by my attorney as the court would expect. Ding, 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 we have the return of the illustrious pretend judge. This is just her version of the pretend judge in the appeals process. You won't treat me right, Miss Cashman, so I have to add pretend judge so that you can calm your attitude and treat me how you would treat me in front of a judge. So much, I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added pretend judge to I added pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems like everyone else, not to remember. I am innocent until adjudged otherwise.
We, the jury, find the defendant guilty of murder in the second degree.
Ms. Boone.
Electric chair.
Holy shit. Court sentences you to life in the Department of Corrections.
She treats me as if I am not. After my introduction and explanation with pretend judge in the room or on the phone, I am trying to help her understand how she is making herself extremely unwelcoming. When in front of a real judge and in the courtroom is how she should treat me, her client, at all times. I should not have to invent pretend judge in order to be, and am not at all wrong for wanting to be, respected, no matter the outcome. I am innocent until adjudged otherwise. My attorneys, everyone's, should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. I should feel secure, highly confident, proud in her representing my life. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her inimical attitude towards me.
And it doesn't matter how dumbed down I am to myself to try to coexist with her. I've even come up with a solution to have a pretend judge in the interactions with her, so she would try, hopefully, to treat me appropriately and professionally, which she does not do. The last time we spoke was on May 3rd, where I got up and I left the room because I could not take how she was treating me any longer, and it was every single time. So much so that I have to incorporate a pretend judge in order for her to treat me somewhat appropriately. And I feel that she is untruthful with me and full-blown prejudice against me, which I believe adds to her nasty attitude towards me. And I do not trust her. And it's a matter of ethics and professionalism with how she should be treating me, and I shouldn't have to come up with a pretend judge in order for her to do so.
Because that's what the judge would expect. Hear that, DCA? We both are on the same page. They just won't listen, right? I know what you would expect. No, they would expect you to listen to their order and leave them the F alone. It's almost impressive how many times she repeats the same exact patterns in different contexts and situations. You wouldn't even think that you could apply those same and accurate behaviors to every situation you come across in life. She somehow makes it work. Against her best interest. But whatever. Alright, and with all of that, I think this is where I'm going to wrap this video up for this letter. I mean, I stretched a 2-minute letter into 2 hours. I don't think there's anything else I could talk about. But it was interesting, you know, she's never going to give up no matter what. And that would almost be admirable if she wasn't such a bad person. So yeah, let me know what you think about this letter and everything we talked about. And if you liked this video, remember to like, comment, subscribe, dislike if you're feeling it. Until next time.